You're watching Good Evening San Diego.
Joining us now to talk a little bit more about the uptick in smash and grab crimes all across California and the proposition that may be fueling the surge is criminal defense attorney Vikas Bajaj. Good to see you again, Vic. Thanks for coming by.
Thank you, Logan.
So a lot of reasons why these smash and grabs are happening, but one reason a lot of people are pointing to is this Proposition 47 makes it less of a penalty if you get caught with stolen merchandise, more of a misdemeanor than a felony.
Right, the Safe Neighborhoods and Schools Act is what you're referring to, and that in 2014 through Proposition 47 made it a lesser punishment, as you point out, for certain theft, fraud, embezzlement type crimes. So anything under $950 in value would now be a misdemeanor, not a felony. Now, the real gravity of that is misdemeanors can only be punished up to 1 year or any kind of a combination or alternative sentence below that. But felonies are eligible for state prison up to, let's say, 3 years on most fraud charges. So it made a lot of felonies misdemeanors, which took away the hammer in the legislature and law enforcement for those committing thefts and crimes. Now, the issue is Proposition 47 the reason for these smash and grabs and stores over 3 decades closing down in retail areas in San Francisco? Yes and no. It takes away the hammer, but it really just gives crime-friendly, safety-conscious, or safety-adverse district attorneys an avenue or a way out. Because of Proposition 47, many district attorneys say, well, we're not going to go ahead and prosecute these felonies because now we have this new proposition. But district attorneys, especially one, for instance, ours, Stephan in San Diego here, has said, well, I'm not playing that game because when you have smash and grabs, you also have vandalism and you also have robberies. Even just a minor tussle with a store clerk can be a robbery, and those are felonies that can and are prosecuted here.
And when you hear about that Prop 47, you think, okay, maybe they're just going in and stealing $800 worth, so if they get caught, it's just a misdemeanor, not a felony. But you see the video here. I mean, sometimes it's 50 people, they've all got hoods on, and they're grabbing Louis Vuitton bags. I mean, they're running out of the store with thousands of dollars worth of merchandise, and then they're getting in cars, oftentimes with no license plate on them, and then kind of speeding away. It seems like cops don't want to get involved. It's hard to ID these people, and now with eBay and other online marketing, you can sell a Louis Vuitton bag, and nobody even knows if you stole it or it was yours to begin with, it seems like.
What a classic example of the law being reactive and not proactive. So post-2014, post-Proposition 47, now the governor and other legislatures have said, we need to address this problem that you described just a moment ago. And so now there's an organized retail theft crime, which ups the ante, and it requires more than one person to have an agreement or a conspiracy to steal items and, for instance, sell them online, as you pointed out. You also have federal crimes. So let's not forget Secret Service, when they're involved with identity theft or even things where theft crosses state lines, you have what we call Hobbs robbery indictments, and that really ups the ante. So if a prosecutor wants to be tough on crime and high on safety of the community, the tools are there. Propositions 47 and 57, for instance, later on, just made it easier for prosecutors to say, I now have a reason to be soft on crime.
As a defense attorney, would it be difficult to represent one of these shoplifters? Maybe they have footage of them with the camera on their face. I mean, what kind of defense could you provide somebody like that?
Usually when you have a client, and back in my earlier days, I would represent those who are charged with lower offenses, misdemeanor offenses, not conspiracies or organizations or federal indictments by any means. And if there is that forensic evidence, facial identification, fingerprints, identification being used falsely and run through the scanner, it's a mitigation case. Judge, my client did it because of X, Y, and Z. You never go to the box, as we say, or a jury and try to attack that forensic information on a guilt or innocence basis. It's really, Judge, take it easy on my client because of mitigating factors which outweigh the aggravating factors.
Maybe just try to get a plea deal if it looks like it's too tough of a case to win.
More often than not, these cases are plea bargained and they're resolved. We've seen the results here in Southern California with a couple of very serious penalties in the decades for those who have decided to just roll the dice and have their guilt or innocence decided by a jury.
Vic Bajaj for us. Thanks, Vic. Thanks for coming by.
Thank you, Logan. Always a pleasure.
All right.